The courtroom went silent. A confessed killer walked free because prosecutors were 24 hours late. The Sixth Amendment speedy trial clock had run out. And there was nothing anyone could do. December 1972. The Supreme Court issued a ruling that would haunt prosecutors for generations. In Barker v. Wingo, they established a four-factor test to determine when the government takes too long to bring someone to trial. Length of delay. Reason for delay. Whether the defendant asserted their right. And prejudice to the defendant. But here is what most people do not understand. This test created a constitutional time bomb. Once that clock starts ticking, every single day matters. Every continuance counts. Every procedural motion adds pressure. And if prosecutors miscalculate by even one day, decades of investigation can vanish instantly. The question that should keep you watching is this. How did we create a system where guilty people walk free on technicalities? The Founding Fathers had good reasons for the Speedy Trial Clause. In 1776, British authorities would arrest colonists and hold them indefinitely without charges. No trial date. No evidence presented. Just years rotting in jail while the Crown decided your fate. The Sixth Amendment was their solution. But they never imagined modern criminal justice. They never anticipated cases requiring years of forensic analysis. They never foresaw DNA testing backlogs stretching 18 months. Today, the average felony case takes over 300 days from arrest to trial. Complex murder cases often exceed 2 years. And every single day, prosecutors walk a tightrope between thorough investigation and constitutional violation. If this is already making you think differently about criminal justice, drop a like so I know to keep going. The system is far more fragile than anyone realizes. Now let me put this in perspective. The Federal Speedy Trial Act gives prosecutors 70 days. 70. That is from indictment to trial. Miss that deadline without valid exclusions and the case gets dismissed. State rules vary wildly. California allows 60 days for misdemeanors. New York gives prosecutors 6 months for most felonies. Florida's speedy trial rule provides 175 days. But here is where it gets complicated. Certain delays do not count against the clock. Competency evaluations. Defense continuance requests. Pretrial motions. Interlocutory appeals. Smart defense attorneys know exactly how to manipulate these exclusions. They file motion after motion, then suddenly demand their speedy trial rights when prosecutors are unprepared. It is legal chess played with human lives. And prosecutors are often playing defense. Think about that for a second. The same constitutional protection designed to prevent innocent people from languishing in jail has become a weapon for the guilty. In 2018, a defendant in Ohio was charged with aggravated murder. The evidence was overwhelming. Eyewitnesses. Forensic evidence. His own recorded confession. The prosecution had everything. Except time. A scheduling conflict pushed the trial date. Then a judge retired mid-case. Then COVID hit. When prosecutors finally brought the case to trial, the defense filed a speedy trial motion. 4 years had passed since the arrest. The judge reviewed the Barker factors. Length of delay. Clearly excessive. Reason for delay. Mostly government fault. Defendant's assertion of rights. Properly filed. Prejudice to defendant. Witnesses had moved. Memories had faded. The motion was granted. But that is not even the worst part. The prosecution appealed. They argued exceptional circumstances. They cited the pandemic. They presented evidence of defense delay tactics. The appellate court upheld the dismissal. Case closed. A confessed killer walked out of that courthouse a free man. And here is what nobody tells you. This happens more than you think. Department of Justice statistics show approximately 3% of federal cases are dismissed for speedy trial violations. That sounds small until you realize it represents thousands of cases annually. Murderers, rapists, armed robbers, walking free because someone miscounted days on a calendar. Subscribe if you want to see how this keeps happening. The system is broken in ways most people never see. And what happened next in constitutional law made everything worse. And then the defense made a fatal mistake. Not the defendant. The entire defense bar. They got greedy. Defense attorneys started filing speedy trial demands immediately after arrest, before discovery was complete, before evidence was processed. They created a strategy called demand and delay. File the speedy trial demand on day 1. Then request continuances for every legitimate reason imaginable. When the clock runs low, withdraw all continuance requests. Suddenly demand your constitutional rights. It worked brilliantly until judges caught on. In 2021, several courts began applying the Barker factors more strictly against defendants who played games. But here is the problem. The Constitution does not care about gamesmanship. If the government violates your speedy trial rights, you go free. Period. Drop your prediction in the comments. Should courts be allowed to consider defense manipulation? And this is where everything makes sense. The speedy trial clock is not a bug in our justice system. It is a feature. The Founding Fathers knew that government power must have limits. They understood that a government which can hold you indefinitely without trial is a government that can destroy anyone it chooses. Yes, some guilty people escape because of speedy trial rules. But the alternative is far worse.